I'm your host, Eric, but joining me today is Michael Hammond and Ann Walsh, two partners at Corporate Immigration Partners. Ann and Mike, thank you so much for joining us this late morning.
Yeah, happy to be here.
So, Mike, I thought I'd pick on you first and ask if you can talk a little bit more about your immigration career, kind of what drew you into the field, how long you've been practicing, and any other fun facts about yourself.
Sure. No, I've been doing immigration law for over 30 years. I know I look a lot younger than that, but it has been 30 years. I primarily work in two spaces, the IT staffing space and in healthcare. And so retrogression is a fun, common topic for me to talk about. So excited to be here.
Thank you so much. Excited to have you on. And Ann, it's always a pleasure to have you on. I think I've lost count on how many of these webinars, live streams, or podcasts we've done over the years. But it's always a pleasure. How are you doing?
Thank you.
And
Good.
What's new with you?
Good. It's hot out. Obviously, it's summer, and it might be much hotter where you are. But I'm in Milwaukee, Wisconsin, and we're not built for this. So, as Eric said, my name is Ann, a partner at CIP. I'm in my 13th year at the firm, lucky 13. My practice primarily focuses on employment-based, heavy in electronics, manufacturing, and software industries presently, though I've done a wide range of immigration matters from extreme pogo stick jumpers to startups to working with CEOs of Fortune 500 companies. I also enjoyed the family-based side of immigration and primarily work with those case types through my involvement with active military members. So happy to be here.
Thank you so much, Ann. Well, let's hop into our main our content for today. But quick word. As always, please excuse any audio or video hiccups that might occur with live streams. This event is being recorded, and so it'll be available for later viewing on our Onward Global YouTube page as well as our LinkedIn page, just in case anything happens if connections sputter here and there. Additionally, if you do have questions for Mike or Ann throughout the conversation today, please go ahead and put those in the comments section that you should be seeing below the video, and we'll do our best to address your questions. So, Ann, we are obviously a little past the halfway point in the month of June, and thought we'd just spend about like 5 minutes or so just to see what is the latest when it comes to business immigration. In the past, we always used to call these kind of like a mid-year state of immigration, but just wanted to hear your thoughts and insights on some things that might be top of mind for you and the firm.
Absolutely. Let me know if I have an audio or video problem, as I'm seeing some glitching on my side. So please do let me know. I like to say there's never a dull day in immigration law practice. It's a very live practice, and we are experiencing changes constantly. So as evidence of that, today, President Biden is expected to announce a program for persons who are undocumented and married to U.S. citizens, which is expected to include protection from deportation and a path to permanent residence. So, to my knowledge, that has not been released yet, but may have been this morning, and I haven't caught it, but is expected today. And that's relevant to today's session because permanent residence is a more formal term for a green card, and spouses of U.S. citizens are exempt from allotments that we're going to talk about with regard to green cards that are available per year. So that's really interesting, awaiting that to come out, and again, expected today. Otherwise, in the last few months, we have seen on the themes of how do I get to the U.S., how do I stay in the U.S., on the how do I get to the U.S. side, we're seeing a lot of interest and pursuit of work-based visas, the H-1B cap, filled up with a lottery, about 25% selection, maybe 20% selection rate this year. Thankfully, that selection rate normalized from the year prior because USCIS implemented a beneficiary-centric selection method. So thankfully, we did see that normalization in the selection rate. Similarly, H-2B cap regularly being reached, and those are largely for seasonal workers. In terms of how do I stay, we are seeing some policy shifts toward expanding options for individuals. For example, there's a green card category Schedule A, Group 2, that gets to skip what we call the PERM process, the Department of Labor process in green card sponsorship. And definitions within that category were expanded, so more people could be eligible. So we've seen that. We also saw the Department of Labor issue a request for information on Schedule A more broadly in terms of exempting STEM workers from the PERM process, needing to go through that Department of Labor process. So no policies out, no rules, no proposed rulemaking out on that possible Schedule A STEM. The comment period ended a couple weeks ago. That said, we're excited to see where that possibility could go. So as I started with, never a dull day. And it's an exciting field to be in.
Definitely. Appreciate the updates, Anne. Never a dull day and never a dull future. It's always something to look forward to. Great. Well, definitely check out Envoy Global and CIP for more news alerts, particularly things that are happening at this moment or will be happening. And be sure to check out Envoy Global's 2024 U.S. Immigration Trends Report, where we surveyed over 500 HR professionals from across the country to gauge their sentiments and thoughts on the current state or the state of U.S. immigration when we surveyed them, as well as other areas that they're thinking about in the next 12 months. So let's hop into our main topic for today in visa retrogression. So, Mike, for today's events, I think it would be helpful, or for today's event, I think it would be helpful if we first start with some important terms and concepts our audience should keep in mind as we go about the discussion. What are some of these terms and concepts that you want to discuss?
Sure. First of all, I think it's important to kind of understand just the basics of what retrogression is. And the concept of retrogression is simply that there is a line that has formed in our discussion today that we're focused on employment-based visa category. So there's more demand than there is supply. So a line forms, and we call that retrogression. Some key terms and key things we're going to talk about is a priority date. A priority date is like your spot in the queue, your spot in the line. You get the priority date if you are filing through the U.S. through a program that uses PERM. Our labor certification, your priority date is the date your labor certification or PERM was filed. If you are exempt from that, like Schedule A, which primarily is RNs and PTs, but is being expanded into other fields, you get your priority date when your I-140 is filed. So priority date is your spot in the queue and your spot in the line. The charts that we talk about all the time come on what's called a visa bulletin, which is a publication put out by the Department of State. It's done monthly. It comes out like we just saw the July visa bulletin last week. So it comes out usually the middle of the month before. So that's an important. That bulletin has two charts that are relevant. It has what's called a final action date chart, and it has a date for filing chart. The final action date chart is the chart, and Eric, if you can share the screen for a second. The final action date chart is the chart that, let's see, scroll down a little bit there, Eric. Right there. Hold it right there. That'll be a good spot. Okay, so the final action date chart is the chart whereby they can actually issue you the immigrant visa, the green card. Okay, immigrant visa and green card are interchangeable terms. So final action date chart, I can get my green card. If you're overseas, the final action date chart is particularly important because that's when you can have your interview and complete your process. If you're in the US and you filed a 485, it's an important part because of the fact that that is when your case can be adjudicated and concluded. You'll note on this chart, we'll jump back in a second to the other type of chart I mentioned, but you'll notice this chart is broken up by categories and by countries. So primarily we focus on categories 1, 2, 3. That just stands for first employment-based EB. People call it EB1, EB2, EB3. EB simply refers to employment-based. First are generally multinational executives and a couple other categories. Second are generally individuals who have master's degrees or bachelor's plus 5 and variety. And third is broken up into 2 categories, skilled and professional. So it's basically everyone else. And then there's a category you'll notice under third called other worker. Those are what we'd refer to as unskilled, those occupations that require less than, say, 2 years of work, education, or experience to achieve. And then you'll notice if you kind of look past you'll see a big category called all chargeability areas. And the easiest way to explain that is to look at the other categories, which if you were born in China, India, Mexico, or the Philippines, you have your own chart. Everybody else falls into this other category. A lot of people refer to it as ROW, rest of the world. And the columns, the dates that are in the column, is the priority date upon which they are now working. So, for example, if we were to go to the Philippines and go down to the EB3 category, it says November 22nd, 2022. By the way, this is the June bulletin, not the July bulletin. We did that intentionally because July bulletin is so depressing. We thought people would just leave the show immediately. We didn't want that to happen in the first 10 minutes. So this is the June bulletin. So if you're overseas and you have a priority date prior to November 22nd, 2022, you can go and have your interview and be adjudicated, get your visa issued, and then come enter the US. If you're in the United States, you have a 485 that's pending and you have a priority date earlier than November 22nd, 2022, then your case can be adjudicated and you can get your 485 approved and your green card mailed to you. Leave that chart up just for a second, but let me reference, there's a second chart in each of the visa bulletins that is called the date for filing chart. And that may seem logically to mean that would be the date you could file your case. And I think that's a proper interpretation of that, but that's not how it's interpreted. So what happens is the Department of State releases these bulletins each month, and then the USCIS looks at them and says, we might want to use the date for filing chart for filing. We might not want to use it for filing, and they force you to use the final action date chart. A couple other terms that are really important. These visa bulletins work on a fiscal year. So October 1st is the date of the government's new fiscal year. And another really important concept is that the visa bulletin or the visa numbers overall are use it or lose it. So in general, we have a minimum of 140,000 allocated to the employment-based side. If they're not used by the end of the fiscal year, September 30th, they don't carry over into the next year. They are simply lost. So if we pretend we have 140,000, it's not correct, but let's pretend we do, and we only use 130,000, then 10,000 immigrant visas got kind of wasted. And then the last kind of important concept is to understand that the overall numbers of 140,000 of immigrant visas is not 140,000 workers. It is 140,000. It includes spouses and children on that category. So if you have a worker who's got a spouse and 2 kids, they take 4 from the allotment. And then one other quick thing, I said that was the last thing, that was a lie, that I forgot, is there is a per country limit, which is why these other countries have their own line. And then there's another limit on what's called the other worker category, which is a 10,000 max limit. So those are some key concepts and some kind of big picture ideas to kind of set the stage.
Awesome. Appreciate it, Mike. Did you want me to go up to the other chart?
Nah, I don't think so.
Okay. Cool. Let me stop sharing. And then, Mike, next question for you. Or, sorry, Anne. Additionally, to help lay the groundwork for today's discussion, can you walk us through the immigrant visa process?
Mike touched on it through his key concepts introduction. So the immigrant visa process can take place outside of the US or inside the US. One way or the other, in the employment based context, you're going to get to an I-140, an immigrant petition for alien worker. That gives you your priority date. And as Mike discussed, you wait in line until you're eligible to proceed to the final step of the process. Inside the US, that's called adjustment of status, filing the I-485 application for the green card. Outside of the US, I call it consular processing. It is processing ultimately through the embassy or consulate. And those individuals receive an immigrant visa into their passport, travel to the US, and then they receive their green card is mailed to them. Whereas in the US, you receive the green card straight away at approval.
Right. Mike, back to you. So the theme of today's our event is on visa retrogression. So I think you touched on it a little bit earlier, but diving a little bit more into it. What is visa retrogression and how does it work, so to speak?
Yeah, so as a practical matter, I think it's important to kind of split this up into whether you're waiting from overseas or you're waiting from inside the US. If you are waiting for overseas, visa retrogression is fairly simple in that it is simply how long it's going to take you to get to the US. So when your line is short, you're going to get through the US based upon simply the processing time to get through, say, the I-140 or the PERM and then the I-140 and then the NVC center and then the interview notice. It's just going to be whatever process time there is. Whereas with retrogression, it's going to add a wait. So you get to a certain stage, your I-140 is approved, and now you wait. So in that respect, it simply delays when you can arrive in the US. The effect of that is pretty significant. For example, if you have children that are older, that what we would call age out. If they, if you've got a child and you're starting this process when the child's 19 and your expected wait time is 3 years, then it's likely that child will not get to immigrate with you to the US. So there's some pretty huge implications other than just, I didn't get to come as fast as I wanted to. But practically speaking, outside the US means you're waiting. Inside the US, it's a little different. Because generally speaking, most individuals, not all, but most individuals who are going through the green card process from inside the US are in some other legal status. And the majority of them are in a legal status that allows them to work legally. So you have a delay as well. Maybe it's a delay in actually being able to file your I-485, which can impact travel, international travel, can impact opportunities for spouses, can impact career advancement or portability, changing jobs. All those things are significantly impacted. But unlike individuals overseas, you are still here, you are still legal, you are still able to work. For certain individuals who are here and not in legal status, or maybe they're in legal status, maybe as a student, that's a common status, but not eligible to work, then a delay can mean that they've got to decide, I'm going to re-enroll in school again and go back to school. And maybe that's not what their career needs. Maybe that's not what their pocketbook needs, those things. So there are significant implications as a practical matter as to what retrogression means. But big picture, if you had to put it in one word, it just means wait.
Does retrogression affect certain industries, skilled versus unskilled, offshore versus people already legally working here? wondering if does that impact some things differently than others?
Yeah, absolutely. So the other worker category, which is generally your unskilled category, think maybe cooks, common labor, maybe in the healthcare industry, CNAs type workers, technicians, some manufacturing technicians, a variety of occupations are what they call in the other worker category. And with a 10,000 max per year that can be allotted, they're going to have significant delays compared to everyone else. Their dates move forward not as fast because it's simply based upon usage. The numbers that are available right now, as of November 2023, there were a little over 45,000 in queue at the NVC Center, and with only 10,000 per year, assuming no one gets added to the list, which of course is not true, and assuming there's no one in the US that's under that category, you do the math, that's a fairly long line. Now, I don't think it's as simple as dividing 10,000 into 44,000 and going, oh, it's 4 years. I don't think that's accurate either. But nonetheless, huge line. There's also a bigger impact with retrogression to certain occupations that don't have a good visa to get into the US. If I'm a software engineer, employers can bring me into the US on, say, an H1, possibly even an O, maybe an L, depending on the circumstances, and then do my green card here. And so the long retrogression, the long line, is significant for me because it takes me longer to get a green card, but I'm allowed to work here. However, if I'm in an occupation where there's not an easy visa, for example, registered nurse is the most common one. The H1 is a very difficult visa to get, and most RNs do not qualify for an H1. And so they have no way to get here and wait while they're here. So unlike a software engineer, registered nurses are generally overseas waiting, and so the wait makes it longer for them. So those would be a couple industries and a couple occupations that I think are impacted disparately due to retrogression.
Knowing that, and throughout your career, what have been and what are your words of wisdom for employers and how they can help their employees navigate everything?
Well, I think you have to, if you're an employer, I think the answer is very different than if you're an employee. If you are an employer, you're looking at how long is retrogression going to take? And am I going to still have this need in whether it's 2 years, 3 years, 4 years, 5 years, whatever the number is? And in certain occupations, you can easily say, yeah, I'm still going to have that need. So I'm still going to pursue this process. Then as an employee, you have to go, is that worker still going to be available? Because if I'm going to go through a process that's going to take 3 years, I might still have a need in 3 years. But is that worker going to still be waiting for me for this job in 3 years? In some occupations, maybe. Some occupations, it's too long. So at some point, you have a maybe called a line in the sand. When retrogression gets to a certain point, I'm not going to start new sponsorships because it's taken too long for people who are offshore. In the US, it's not quite significant because you can work the person usually while you're waiting in the line. So you don't have that assessment. For workers, it's not quite as critical because you may want to come to the US and you may want to come now, okay? But coming in 5 years may still be better from your perspective than not coming at all. So the long line is problematic for you, but it may not be a point of, I'm not going to pursue this. And keep in mind, generally speaking, the costs are all borne by the employers. And so cost does factor in to that situation.
And is there a time of the year when retrogression tends to happen more often?
Yes. As Mike introduced, they're on the fiscal year, so October through September. So as we get to the latter part of the year, which we're in now, retrogression typically gets worse because the agencies are communicating, trying to figure out how many green cards they have left to issue, trying to figure out that no country can get more than 7% of the allotment. So as the year goes on, retrogression typically gets worse, either stalling out or moving backwards. And then come October, I always say October is the friendliest visa bulletin of the year because the new green cards are available for the year. So we typically see the most advantageous dates in October.
Are you in the CIP expecting that this year as well?
Yes.
Got it.
Mm-hmm.
So, Mike and Anne, moving on to second part of today's discussion, will visa retrogression end, if ever? Want to open the floor, pose a question, and then let both of you share your thoughts and insights. So maybe, Mike, we can start with you. What are your thoughts about if visa retrogression will ever end?
Well, I think the reality is it will only end in one of two circumstances. Either there's a fix, a solution, which would be legislative, that we increase the number of 140,000 to something higher so that the supply gets closer to meeting the demand. Or without increasing the number, we would exempt certain categories and certain occupations from the count, which is a de facto way of increasing the number. So legislative approach could end things, and that would be a positive approach. I tend to be somewhat cynical, and for all of my clients who are on this call, you're laughing at my use of the phrase somewhat, but it's true, is that I find it hard to believe that our current Congress is going to get together on whether today is Tuesday even, on something like retrogression. There have been a lot of bills posed and pending and a lot of different solutions proposed over the years. And we've had some times where we've gotten super close, but nothing to the door. So that's one way retrogression could end, is we get some sort of legislative. I think we could get something halfway, let's call it, that would affect U.S.-based individuals. In that right now, the rule is that you have to have a current, or you have to be at the front of the line, priority date in order to file your I-485, regardless of whichever chart they're using. There have been policies proposed over the years that they would change that policy and allow individuals to file as soon as an I-140 was, in most approaches, approved, so that you know you're eligible. You're just now waiting. There was a rumor that the White House was actually going to make that change last year in the fall. We saw a draft of the announcement even, and then it never was released for whatever reason. But that would be kind of a halfway solution. You might still be waiting, but you would get the benefit of being in the final state. And then to the negative side of things, is retrogression would end if, in fact, the demand went down. So if we entered another depression, recession, whatever you want to call it, if you go back to 2009, during that time frame, we had a significant where there was not nearly as much retrogression. Why? Well, because there was less demand, because all of a sudden the job markets dried up in the U.S. We were also significantly impacted to the positive as a result of COVID. We got a huge bump on the employment-based green card side that impacted retrogression in a very positive way as a result of COVID, because there's a rule that's been around since the 70s that any unused family-based numbers that were unused in the fiscal year got added to the employment-based 140,000. And obviously during COVID, the consulates were closed. There were no visas being issued to family-based cases. Basically, only employment-based cases were getting visas issued. Plus, there was just a natural demand, lack of demand. People were not traveling, right? People were sitting in their houses watching YouTube and TikTok. And the numbers were huge. So, for example, in fiscal year 2021, instead of 140,000, we had 262,000 that we were allowed to give out. And they actually did give out, almost 200,000. In fiscal year 2022, We had 281,000, so not quite double, but pretty much double. And they actually used 280 of that. And then this last fiscal year, we had 197,000. So again, about a 50,000 increase, all associated with COVID. So if you're being completely dark and this were a episode of South Park, we would say another COVID coming along would help retrogression on the employment-based side. I think that sounds pretty harsh, though. So, and probably has more positive things to say.
Well, real quickly though, Mike, you're referring to the infamous October 2020 visa bulletin, right?
Well, it was in October 2020, but it was also throughout all of 2021, 2022, 23. Even this year, we're still getting a little bit of a bump. Instead of 140,000, we had 161,000 this year. But the huge impacts were in fiscal year 21 and 22, where you had basically double the number. So, and we're now back to normal. So for those of us who love 2021-22 processing and are like, well, when's it going to get back to that? Well, it's not going to. That was the aberration. Now is real.
So, Anne, spotlight on you. Mike said you have some positive thoughts.
Yeah, absolutely. So as I was growing up and I had a challenging task at hand, my dad would ask me, how do you eat an elephant? And your immediate reaction is, well, you don't. But he would say, one bite at a time. So there have been bills introduced in Congress that would make positive change to visa retrogression. As Mike said, it's unrealistic to expect, from our perspective as employment-based immigration attorneys, the perfect bill to pass anytime soon. That said, we could try to take a bite, right? Let's get something that can positively influence the lines, just one bite at a time if we can't get our sweeping solution passed. So there have been bills, the Immigration Visa Efficiency Act, I believe it's called U.S. Citizenship Act, that have some really interesting ideas. And that's included eliminating the 7% country allotments, max allotments, which would help normalize largely India with the rest of the world. I've also seen the recommendation that STEM PhD graduates from U.S. universities be exempt from the green card lines. So that's an interesting way to retain U.S. talent and allow those individuals to skip the green card lines in the way that in the very beginning when I started, I said spouses of U.S. citizens are not in the lines. So that possibility that STEM PhD graduates from U.S. universities would not be in a line. And then there's other things that Congress can do to help alleviate some of the consequences that people are dealing with in retrogression. So as Mike said, one of the leading issues is children aging out. Once children are over 21, they're no longer a dependent on the parents' green card case or their visa. So I've seen the idea that so long as the child is its qualifying dependent and in the United States by age 18, they are considered a child until the green card is issued. So there's a lot of interesting ideas within the bills that have been proposed. And my perspective on it is one bite at a time. If we can make progress one bill at a time, that's something, because we might not realistically get our sweeping immigration reform bill that we'd like to see.
For sure. And I guess maybe as a follow-up, do you think maybe those one bites at a time, is it purely legislation, or do you think there are things that maybe the executive branch could do, USCIS, DOL, etc.?
Yeah, I mean, there always are. Congress writes the laws, and then the executive branch implements the laws, executes the laws. So they have some leeway into how they interpret what they have the power to do.
Mm.
An example of that is what we're expecting from President Biden today with regard to how he's understanding the parole in place program and allowing spouses of U.S. citizens who are undocumented a path to a green card. So yes, that is possible.
I guess open question for both of you. I'm forgetting who it might have been. Mike, you mentioned it. Schedule A. I know I've been seeing that in the news. It's been talked about. I know they're looking to kind of change that up. Could that have an impact on retrogression?
The expansion of Schedule A into more STEM occupations, in my opinion, what I think that the individuals who would likely qualify for that are going to be individuals that would have already been in the line for something else. Or would, if they weren't going to qualify for that, they would have simply done a perm. So I think it'll affect how they're processing cases, but I don't think it will affect the retrogression numbers.
Great. Well, want to take a quick pause here. Take a look at the clock. We are at 11:43 Central Time. If anyone has any questions for Mike and Anne, now is the time to type those in, and we will do our best to address them before we wrap up today's event. So Mike and Anne, while we wait for any potential questions to come in, I think you kind of both hit on, like, what can the government, do to kind of end retrogression, if at all. But I guess I wanted to pivot more towards the employer and employee side, and I know we talked about it a little bit earlier, but just to see if there are any additional thoughts on how employers and their employee populations can best navigate retrogression, things to keep in mind, potential best practices, and just things of that sort. Maybe if you have any insights regarding those.
Yeah, absolutely. It's important to be educated on the categories, because if you're educated on the categories, you can understand if you can move up a category in order to be in a more advantageous line. So ensure that you're getting that information from your immigration attorney, and that each and every individual is being looked at holistically to determine if there is a better option or a realistic pathway to a better option that works with both the employees' career and personal interests and the employers.
And I would add in that if you are an individual, particularly if you are offshore, the most important thing for you to do is to take care of the parts that you can take care of. So if you are an RN or a PT offshore, take care of your licensing exam, take care of your English exams, do all the parts you can do so that you can move forward. Also, I often talk to people who will have a consultation and look at the line and say, oh, this looks 2 years long. It's so long, I'm not going to do it. And then 3 months later, they want to have a second consultation to talk about the line. And the line's still 2 years long, but if they would have gotten in it 3 months ago, they would be 3 months down the road. So I think sometimes we get a little overwhelmed by how long it looks, and we fail to move forward. And the reality is we probably should just err on the side of moving forward. I think for a lot of employers in the U.S., I would encourage them that with lines, as long as they are, that they look at their internal immigration policies for how long they want a worker to work for them before they start the green card process. I think that whether you change it or not, I think it's at least worth relooking at whether your worker who is going to be advantaged the sooner you file their case, whether it's appropriate to keep them waiting 6 months, 9 months, a year before you start. I would at least reassess that particular program.
Got it. Great. Thank you both. We did have one question come in, and then we will likely look to wrap things up. Open floor for, so whoever wants to take the question. Is there an update on the Healthcare Workforce Resiliency Act?
Mike?
Well, here's how I answer that one constantly. I'm on a lot of these retrogression calls, and I'm normally on them with a friend of mine who is a wonderful immigration attorney named Chris Musillo, with a firm called Musillo Unkenhold. He's not with our firm, but he is the key dude behind that bill, and he has all the inside information. So normally I would simply point to him and go, Chris, take it away. This is for you. That'd be unfair to Anne.
Yes.
So I can give you an update as to what I have heard as of like 3-4 weeks ago, which is that in its variety of forms, it continues to be pushed. It will continue to be reintroduced. Obviously, we're going to be fairly soon entering a lame duck session of Congress, whereas there will be the same Congress is in effect, but there will be a new Congress coming in January. So that period of time after the elections and before you have there'll be some turnover. And so oftentimes bills can get introduced and passed time. And so that is helpful. There's a possibility that a bill like that, it is unlikely it could be a standalone by itself. It normally would be attached to something else that they decide, whether it's an appropriations bill or something else that could get through. It was, or at least a part of it was attached to the border bill that was the bipartisan bill that was, by all accounts, ready to pass until former President Trump decided to kill it last year. So we were that close to having it passed, and then no longer. So there'll be a fight for it again this year, and then if it doesn't succeed in the next Congress that reconvenes in January, they'll reintroduce it there as well. So, and the idea behind the bill is, for the most part, I'm making it oversimplistic because of my knowledge, is it exempts, as Ann mentioned, exempting certain individuals, and certain healthcare workers would be exempt from the bill up to a certain amount per year. So there you go.
Appreciate it,
That
Mike.
wasn't Chris that asked that question, was it? So he could get like a plus, was it?
No.
Terribly unfair. So, okay.
No. Appreciate you tackling that question. Looks like that is the only question for the day. So as we look to wrap things up in these last few minutes, Ann and Mike, just wanted to see if there are any parting thoughts, anything we might have missed.
I would end with amplify your voice, that this is important to your company. If you're in contact with your congresspersons, great, keep doing that. If not, let them know that your immigrant workers are critical to your success.
Awesome. Well, Mike and Ann, thank you so much for your time today. Be sure to follow Envoy Global, Michael Hammond, and Ann Walsh on LinkedIn for more immigration insights and analysis.